the honourable member for Ottawa South.
Well, thank you, Madam Speaker. I'm pleased to stand this evening to speak to Bill C-75, which amends the Criminal Code, the Youth Criminal Justice Act, and other acts to address delays in the criminal justice system and increases criminal justice system efficiencies. It's about delays and efficiencies. Delays in the criminal justice system significantly impact all of those involved. Under the Charter of Rights and Freedoms, Madam Speaker, accused persons, of course, have the right to be tried within a reasonable time. And should an accused not be tried in a reasonable time, it could result in a stay of proceedings in accordance with new timelines imposed by the Supreme Court in 2017 in its, of course, landmark Jordan decision. Stays of proceedings due to delays undermine public confidence in the criminal justice system. These stays are unacceptable, and as parliamentarians, we must step up to address this problem, which is why we've introduced Bill C-75. The challenge of delays is particularly acute for Indigenous persons and individuals from vulnerable populations, such as those suffering from mental health or addiction issues, who are overrepresented in the criminal justice system. While the volume and severity of crime have decreased over the years, criminal court cases are becoming more complex and trials are taking longer to complete. Data from Statistics Canada shows that the median case completion time in adult courts has increased from 120 days in 2010-2011 to 127 days in 2015-2016, a full week. Another important challenge is the number of individuals in provincial detention facilities awaiting trial, which currently exceeds the number of individuals found guilty of criminal offences and serving their sentence. Statistics Canada recently reported that the remand population has exceeded the sentence population, with adults in remand accounting for 60% of the custodial, that is federal, provincial and territorial, population in 2015-2016. Bill C-75 includes amendments that will streamline and modernize the bail process while maintaining public confidence in the criminal justice system. This will reduce the high population in remand while ensuring our communities are kept safe. The bill will expand bail conditions that police are able to impose on an accused, which will enable their release at an earlier stage and will reduce time spent in custody before their trial. These conditions, however, will be guided by a principle of restraint for police and prosecutors. A principle of restraint means that release at the earliest opportunity will be favoured over detention, and that only reasonable and necessary bail conditions are to be imposed on an accused. As well, Canadian criminal courts process a high number of administration of justice offences, such as breach of bail conditions and failures to appear in court. This volume of cases, Madam Speaker, is bringing increased pressure on the entire system. These less serious offences often involve minor matters that do not compromise public safety or cause economic harm, for example, breach of curfew, but catch the accused within the criminal justice system if they are charged for their breach. Statistics Canada here again reported that in 2000, 2013, 2014, 39% of all cases in adult criminal courts included at least one administration of justice offence. That's almost 40%. For many offenders, being unnecessarily charged and convicted of administration of justice offences is a fast track to the revolving door of the criminal justice system. This is costly in both economic and human terms, and it is avoidable. So with a view to decrease the number of these charges taking up so much court time, Bill C-75 proposes to increase police and prosecutorial discretion for administration of justice offences involving both adults and our youth. The bill gives police and prosecutors a new tool called a judicial referral hearing, which serves as an alternative to a formal criminal charge. For example, after being stopped by police after curfew, the police could decide to charge the accused with breach of conditions or decide not to charge and do nothing more, or could use the new tool and refer the accused to a judicial referral hearing. However, the judicial referral hearing will only be available if the breach has not caused harm to a victim and taking into account circumstances of the accused. At a judicial referral hearing, a judge or justice could decide to, for example, take no action and release the accused on the same conditions, or release the accused after varying their bail conditions, or yet again, order that the accused be detained in custody. But it does provide additional flexibility. This new process seeks to reduce the high number of administration of justice offences that are clogging our court system, 40%, while maintaining public safety. As I mentioned, Madam Speaker, the overrepresentation of Indigenous persons and of individuals from vulnerable populations, such as those suffering from mental health or addiction issues, is a serious, serious issue in our criminal justice system, and it has been for decades. When I began my career as a young criminal lawyer, it became very clear to me very quickly the extent to which mental health and addiction problems were the lion's share of the client base of the firm with which I was practicing. In 2015-2016, Statistics Canada reported Indigenous adults represented 28% of admissions to federal custody and 27% to provincial or territorial custody, while representing only 4.1% of the Canadian adult population. That represents a proportion of about 7 to 8 times higher than their proportion in the general population. The overrepresentation is even more pronounced among Indigenous women and youth. Similarly overrepresented individuals suffering from mental health issues or substance abuse problems. Again, Stats Canada reported that in 2012, of the 2.8 million Canadians aged 15 and older that reported at least one mental or substance use disorder, such as depression, anxiety, alcohol, drug abuse, or drug or alcohol dependence, 1 in 3, 34%, reported coming into contact with police for at least one reason in the 12 months preceding the survey. Of 2.8 million Canadians aged 15 and older with such a challenge, mental or substance use disorder, 1 in 3 have reported interfacing with the police in the 12 months preceding the survey. That's an extraordinarily high number, Madam Speaker. These Canadians who reported a mental or substance use disorder were about 4 times more likely than those without a disorder to report being arrested by the police. Currently in the bail process, the conditions imposed on the accused should be the least onerous and only what is necessary and reasonable. The principle of restraint in C-75 will limit the circumstances in which conditions prohibiting the consumption of drugs or alcohol are imposed. This is an important measure because it is going to help alleviate the disproportionate impact of the criminal justice system on those living with addiction. Police or courts will impose a condition only if the condition is reasonable, considering the offence that they are alleged to have committed, that the condition is necessary to ensure the safety and security of any victim, and if the officer feels the accused will be able to comply with his condition. Madam Speaker, in short, there are many other reforms in Bill C-75 that will help transform our criminal justice system. It's important for honourable members here tonight to consider the bill as a whole, not to view any component in isolation, to remember that these questions can and must be taken to the Standing Committee on Justice to review, to poke, to prod, to ask probative questions, and to improve the bill. These changes ensure that the rights of both victims and accused are protected while maintaining public safety as a paramount principle. In closing, overall, the bill aims to establish a criminal justice system that will best serve the Canadian public. I urge all members on all sides of the House to support this proposed legislation. Thank you, Madam Speaker.